Okay, I have to admit, I have no idea what these lawyers are up to. I don't get it. I don't get it. Now we have Anthony Cotton, who was Dominick Black's lawyer, chiming in on the straw purchase. To his credit, he's not claiming that Dominick Black and Kyle Rittenhouse engaged in a straw purchase, but he never points out that the straw purchase was never in question. Wisconsin law does not ban the purchase of a firearm for somebody else. Well, except under certain conditions. And yet everybody has got this thing fouled up. So I thought, let's just go ahead and take this thing head on. Let's put an end to it. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dread Show.
All right, here we have a recent interview. Now listen to Anthony Cotton, who is Dominick Black's lawyer.
Thomas Binger had repeatedly called this a straw purchase. We heard the testimony during the trial that Dominick said that, he told Kyle he didn't think it was a good idea to buy this gun for him, but they made this arrangement where he would keep the gun until Kyle turned 18 and then he would hand it over and things of that nature. So you don't believe this was, a quote, straw purchase?
Now keep in mind, Thomas Binger has been talking straw purchase all the time. But Thomas Binger knows it was not a straw purchase, or at least, even if it was, there was nothing he could do about it. He knows that Wisconsin law does not outlaw such a purchase. But Binger is playing to the crowd. He's got a whole bunch of lefties out there, and he's trying to anger them by getting them talking about this straw purchase and how obviously it's illegal. I mean, good grief. We know that Dominick Black bought the gun for Kyle, and even the prosecutor is calling it a straw purchase. So Dominick Black, he needs to be in jail, and so should Kyle, because he would be engaged in a conspiracy to commit a crime. Therefore, the fact that Thomas Binger is all talking straw purchase means nothing. It's propaganda.
Well, as Judge Schrader ruled with respect to Mr. Rittenhouse, Wisconsin law permits, I think, an individual who's 17 years old to possess a rifle like the one in question here.
It doesn't matter. I don't understand. Okay, let me back up. Maybe Anthony Cotton is looking at this situation and saying, look, if I go in there and I tell the truth, they're just going to get confused. And therefore, why not just go ahead and play along with the idiocy here and just pretend that a straw purchase was a big part of this and that no such straw purchase took place? I don't know.
So I think the behavior was certainly compliant, at least from my perspective, with Wisconsin law. So I wouldn't describe this as a straw purchase situation at all.
The fact that Kyle was legally allowed to possess a rifle has nothing to do with a straw purchase. It makes no difference. A straw purchase is simply when you purchase something for somebody else. A straw purchase could be legal, but whatever the case, it doesn't matter. Kyle's age has nothing to do with this. And now I'm going to show you why. Okay, so if we're going to investigate the legality of the whole Dominick Black, Kyle Rittenhouse gun deal, you got to go to the original charges. So we go to the Wisconsin Circuit Court Access Database, and let's see what it says. We go on down, and we have the charges. It says here, he was arrested under 948-62C. Intent to sell a dangerous weapon to a person. And I think a lot of people saw that and said, there it is. There's your straw purchase. They didn't bother to actually read 948-62C. And the fact is, the description column in that table isn't wide enough to actually put in the full text. And so there's more than sell in it. So let's take a look at 948-62C. Okay, so the first thing we want to do is to check to make sure that the laws that we're looking at are current. This is 2019. I seriously doubt anything's been done since that time. And it is the most recent version I've been able to find. And you can see, we'll go ahead and scroll down a little bit. Here we have 948.60 2C. All right, it says, whoever violates paragraph B. Okay, we have to go up to paragraph B. Except as provided in paragraph C, any person who intentionally sells, loans, or gives a dangerous weapon to a person under 18 years of age is guilty of a Class I felony. Now notice, it says sells, loans, or gives. The issue here with Dominick Black and Kyle Rittenhouse was whether Dominick actually loaned or gave the rifle to Kyle, not whether he sold it to Kyle. And a lot of people saw sells in that description and thought, well, there's your straw purchase. No, the sells here would be the sale of the gun from Dominick to Kyle, not the sale of the gun from the gun store to Dominick. At no point did anybody claim that Dominick Black sold Kyle the rifle. The question was, how did Kyle get a hold of the rifle? And the claim is that Dominick gave him the rifle or loaned it to him. So we go down to paragraph C here. Now, paragraph C, that's just the writer that adds on a different set of penalties if the gun is used to cause death. Okay, now, you may be wondering, well, wait a minute. Doesn't Wisconsin have a straw purchase law? Well, yes, it does. And if Dominick had been charged with a straw purchase, they would have charged him under that statute. But let's take a look at it. Here it is, 2020, pretty recent, and the title is 941.2905, Straw Purchasing of Firearms. And I know what you're thinking, oh, we got him now. And that Dominick Black, I wonder if Thomas Claire Binger is aware of this statute. We've got to notify him. I think we could get Dominick Black in jail for this because there is a straw purchase law in Wisconsin. Well, let's read it. Okay, so for the following, let's assume that Dominick engaged in a straw purchase with Kyle. He didn't, and there are reasons why I'm saying that, but whatever the case, for the time being, let's just assume that this was a straw purchase. Now let's read it. Subsection 1 says, whoever intentionally furnishes, purchases, or possesses a firearm for a person, knowing that the person is prohibited from possessing a firearm under section 941.29(1)M, is guilty of a Class G felony. And I know everybody's jumping all over this. We got him now. And I have had a lot of people paste this into Twitter to show that I was wrong. Did you read this? It says right here in the Wisconsin statutes. But they never bothered to read section 941.29(1)M, did they? But we're going to. Now keep in mind, it says here that for the straw purchase to be a violation, the person making a straw purchase has to know that he is providing this weapon to someone who has been prohibited from possessing that firearm under this statute. Now you might think, well, Kyle Rittenhouse couldn't possess the weapon because he was underage, but you didn't read section 941.29(1)M. Let's do it. Okay, 2015, this seems to be the most recent. And we go down to here, scroll down, and we come to section 941.29(1)M. A person who possesses a firearm is guilty of a Class G felony if any of the following applies. Now keep in mind, this pertains to Kyle Rittenhouse, not Dominick Black. Again, this is about the recipient of the straw purchase, and that would be Kyle, okay? And Kyle would have to be in violation of this statute for that straw purchase to be illegal. Is he? Well, let's take a look. Has Kyle ever been convicted of a felony in this state? No. Has Kyle ever been convicted of a crime elsewhere that would be a felony if committed in this state? No. Has Kyle ever been adjudicated delinquent for an act committed on or after April 1st, 21st, 1994 that if committed by an adult in this state would be a felony? No. Has Kyle ever been found not guilty of a felony in this state by reason of mental disease or defect? No. Here it's kind of clear that even if you've been found not guilty, they don't want you having a gun if you were found not guilty because you were nuts. Has Kyle ever been found not guilty of or not responsible for a crime elsewhere that would be a felony in this state by reason of insanity or mental disease or whatever? And the answer is no. Has Kyle ever been committed for treatment under Section 5120? I didn't bother to read it. You know it's going to be some sort of mental health issue. The answer is no. Has Kyle ever been ordered not to possess a firearm under Section 51.20 or whatever? The answer is no. Later, as part of his bail agreement, he was ordered not to possess a firearm, but this pertains to the straw purchase that took place months before the shootings. And at that time, no, he had never been ordered to not possess a firearm. Has Kyle ever been subject to an injunction issued under Section 831.12, and this has to do with the Menominee Indian tribe? I don't think Kyle is a member of the tribe. I think we can skip this one. And again, has Kyle ever been subject to an order not to possess a firearm under Section 831.123? I'm not certain how this is different than the one we read just a moment ago, but whatever the case, at the time that the purchase was made, Kyle was not under any orders not to possess a firearm. Now, and there you have it. Kyle never met any of these stipulations. Therefore, purchasing the gun for Kyle would have been perfectly legal in Wisconsin. Now, it would have violated federal law if it was a true straw purchase, and that's another story. But whatever the case, a straw purchase for Kyle of a rifle in Wisconsin did not break any state laws. Dominick was never charged with anything related to the actual purchase of the rifle from the hardware store. So there you have it. It's a dumb argument to claim that Dominick Black should have been charged or convicted for a straw purchase in the state of Wisconsin. Purchase was perfectly legal. Now, what about the feds? Well, the feds have different laws concerning straw purchases, and if it was truly a straw purchase, Dominick could be in real trouble. However, there are other elements that come into play here, and one of those, and it's going to be a huge one, is that after the purchase, Dominick did not give Kyle the rifle, and even in the police interviews, he claimed the rifle was his and that he was not going to allow Kyle to have possession of the rifle until he was 18, at which point he would transfer ownership of the rifle legally to Kyle. I hope I was able to straighten out some of you. Like my video and subscribe to my channel.